us talking about it's evidenced by the promissory note.
Yeah.
Yet it doesn't have any numbers or anything that indicate any promissory note that has like a recording number. It just has a date.
Yeah.
Let me say something about this real quick. I guarantee you that is so incredibly important, because if you look at the new deeds of trust and the new promissory notes written over the last year or so, they have corresponding numbers. So they know this stuff is bad. You know, and we can bring up the fact that the old ones didn't and now they do, so they knew that none of that stuff was right. Yes, there is nothing that you can discover that's going to tie that promissory note to that deed of trust if it's more than 3 years old.
Did you have a question, Eddie? Because I'm going to go into another point. Okay. Everybody kind of wanted to know about what happened the other day in court. Those of you that were there, I was ready to be an expert for this individual in their court case. I prepared an affidavit for her. It was so kick-ass. It really was.
Yeah.
I couldn't wait to get on the stand. I had tons of evidence to just blow that whole case out of the water. And I didn't get the opportunity, and I was crawling in my skin, just dying to get there. But I want to tell you about it because there were some important things that happened that if we ever get lucky enough to get in front of a court like this, man, it would have just been amazing. First of all, a little background. This person signed her deed of trust on the 7th, but it was dated the 6th. Okay, so page 1 of the deed of trust has the date of June 6th. But where she signed and where the notary notarized, every page that she signed, she hand wrote the real date she was signing, which was the 7th. So the document had the printed date of the 6th, but when she signed her name, she actually wrote June 7th next to it. So we knew that she really did sign that document on June the 7th, not the 6th. And the notary notarized it on the 7th, not the 6th. So I had all the evidence I needed. That deed of trust referenced a note signed and dated on the 6th. The note was dated the 7th. She put the 7th next to her signature. That meant that that deed of trust in her case was not evidenced by a note signed and dated on the 6th. Therefore, the deed of trust was completely invalid. Mm-hmm. And that was the major part of her case. Didn't matter all the assignments. You know, their assignments looked good. They were all done right. All the people, they had 4 of them. Everything was looking good there with the deed of trust. That was where we had it. That's somebody texting me. I'll get it later. Basically, the other attorney got up to speak first. There was a motion to dismiss her case.
Let them know that they were saying about the note. Okay.
Yeah. There was a motion to dismiss her case, that they wanted to dismiss it. She was able to provide evidence right then and there and talk to the judge. The judge was very patient, very good, let her do a whole rant of a whole lot of nonsense that didn't mean anything. The other side got up and said, "We got the original note right here, Your Honor. We actually have it." And I was like, let me up there. Let me up there now, because there's no deed of trust there. They brought the original note in the courtroom without the deed of trust. Therefore, they're not together. We had all the evidence we needed of Carpenter v. Longan, and the fact that the deed of trust and the note weren't together because the note was in the courtroom without the deed of trust. I was dying to talk. Didn't get the opportunity. She, of course, didn't bring it up. Did you have a question? Because I'm going to go into a whole lot more.
In that case, the judge was even asking.
Can't hear you.
Carpenter v. Longan.
John!
Wait.
John!
Can't hear you.
Yeah, I just wanted to note that even in that case you're talking about right there, the judge was even asking her how Carpenter v. Longan applied.
Yeah,
and she had it all right there.
Yeah, well, I had printed out for her the quote from Carpenter v. Longan that says that the mortgage and the note may never be apart. They always must be together. And she did read that. The problem was the other side's very tricky. And they said, "Your Honor, we're here to get this note satisfied. We have every right to collect on this note." And they're right. They do. They bought the note. They can collect on this note. they just can't take her
Foreclose.
property. They can't foreclose because that's a deed of trust. The deed of trust is what they used to foreclose with, not the note. And they kept interjecting, we have the lawful right to go after her for the obligation. By golly, I concur, Your Honor, but they don't have the lawful right to foreclose on me because they're not the holder in due course. And they even said, we don't have to be the holder in due course to foreclose on the, or to go after the obligation of the note. You're right. You don't have to be the holder in due course in order to go after the note. They're right. And that she just didn't get it. She didn't understand.
Stop for a
she didn't
second.
practice.
How many people would know this in court? How many of you would know this? Okay. So if you were up, you see what I'm saying about she didn't listen? If she was in there and just said, Judge, it's great. They've got the note. They can sue me, but you can't foreclose on a note. And they have the note, but they don't have the deed of trust. Therefore, they're not together. The deed of trust isn't valid. Your Honor, they just admitted they can't foreclose. Grant the summary judgment, and if they argue anymore, go ahead and arrest them for the fraud they're committing right now. And either arrest them or grant a summary judgment, but if you don't do one or the other, Judge, you're accepting full fiduciary liability right now. And that would have been it. She would have won a friggin' house right then.
There was all kinds of things. First of all, we had gotten a true and certified copy of her note. It only had one stamp on it. Can
Turn
someone
off your
turn that off?
phone.
Turn it on.
Her note only had one stamp on it. It was from the original purported lender, and it was stamped in blank. However, there were 4 assignments recorded in the county recorder's office. So I had worked with her the night before till midnight and said, listen, if they bring the note into the courtroom, even a true certified copy, unless that note has 4 stamps that go along with the 4 assignments, the note doesn't have the proper allonge. And she argued, and she argued, and she argued with me. It's stamped in blank. I don't give a shit if it's stamped in whatever. It has to have a stamp per every assignment. And it had one. At least the true certified copy we had a copy of did. So here we have the note in the courtroom. Your Honor, let me see the note. Let me see how many stamps are on the note. Well, I got 4 recorded assignments here that don't match up. That means the deed of trust was assigned without the note. Again, Carpenter v. Longan, separation of note and deed of trust, we're gone. That was the other issue. We had, okay, the judge says, okay, you got any evidence, whatever, and we got evidence of broken chain of title and this and that, and I've got an expert here. And the judge goes, okay, whatever, why don't you give me a summary of what the report is? And she should have said, no, Your Honor, I've got my expert here, I've got an affidavit here from my expert, and she's here to testify. She didn't do that. She tried to summarize my affidavit without even reading it or understanding what I'd even written. And we went over and over. She made up things. She claimed somehow that the substitution of trustee was assigned to the notary who notarized it himself. I don't know where she got that. I never said that. That was not true. And it was proven in court to be a complete fabricated lie, which made her look stupid. Again, just not practicing, not reading, not listening, I don't know, not using me. It just drove me crazy.
What's one of the rules, guys? If you've got an expert, shut the hell up, let your expert do their job.
Yeah.
Use your expert.
Okay, then they got Mr. Savage. Every time he gets in court, one of the first things he says, and I knew he was coming, I knew he was the lawyer in the case, and I've seen him in action, and I told her, he is going to say that you got a loan, and that you're not disputing you got a loan. So as soon as he brings up the word loan, object, object, object. She didn't object. As soon as he comes up, Your Honor, she's never disputed that she's received a loan. We know she's gotten a loan. There's no argument about the loan. She didn't object. She just sat there. In fact, what she said was, oh, yeah, well, I got a mortgage, and, I got a note, and I owe somebody, but it's just not you.
Okay, that comes from the other guy.
Exactly.
Don't ever friggin' use that in here. Don't. I don't want to hear it. It's wrong. It screws up everything. That is bullshit. That's Garfield shit. That's these other people's shit. It's not, I owe somebody, I know it's not you, I don't know who it is. Well, if you don't know who the fuck it is, how do you know it's not him? That is wrong, it is stupid, it's insane. Don't use it and come here. Don't.
You don't owe anybody anything to begin with.
You bought a house with a promissory note.
Yeah, all she had to say, objection, facts not in evidence. There's no evidence that I've ever received a loan. I have an affidavit from an expert willing to testify here in court that says they couldn't find any evidence I'd ever received a loan pursuant to the deed of trust and the promissory note. All she had to do, she even had her own affidavit that said that. She chose not to file it. She chose not to get it notarized and put it in her case. It was beyond belief. It was so difficult for me to sit there, as you can imagine.
Should have
do you
been
have a question?
slapped her.
Yeah, sure.
No, I just want to make a comment. I know John keeps bringing it up, but failure to object is fatal.
Absolutely.
Always.
Absolutely.
At everything.
The other thing that just really hurt me terribly bad was this was a sniper attack. They had no clue what I was going to say. They weren't forewarned in any way. They didn't have my affidavit yet because I had just filed it that morning. She needed to hand them a copy as she was giving it to the judge, and she was allowed to have me on the stand. How she was going to be allowed without any notification to the other side, I don't know, but the judge had ruled prior that she was allowed to bring her experts in. So I had the golden opportunity to come in and give testimony without the other side having a clue what I was going to bring up. And I didn't get it done. So.
Was that in federal or?
That was in state.
State?
And it was like, we were a group of friends. Everybody, the judge was so kind and nice and patient and listened to her ramble on, and it was just, I mean, I wish I had an opportunity like that.
That's what she's mad about. You couldn't
I
have
know.
it.
Did you notice anything unusual about that courtroom?
I don't know.
There was no flag.
Oh, I'm sorry, I did not notice that.
No,
That's
really?
That's the
interesting.
first time I ever noticed that in the courtroom. No
I just
flag
thought
whatsoever.
it was like a kind of big old group of friends hanging out. The lawyers were actually pretty nice.
I
You
wonder if
know,
that
and-
means anything.
Hanging out on the beach in
Yeah,
Newport.
it was just fun. You know, but what she did was she decided to rant about securitization. She has no facts and evidence that her note is in a securitization pool. She's not found the trust it's in. She has no evidence by an expert. So she went on for 15, 20 minutes about securitization and how this and that and all these things happen, and you know, way back when we used to shake hands with the banker and this, all this nonsense that meant nothing. And she thinks she did this miraculous job in her case. And
But
I
you
mean-
do understand why.
I understand why, but I don't agree. And I just believe that, you know, she's going to get another court date. And whether or not I'll be at all effective with the other side having complete knowledge of what's coming, I don't know. I think we blew a golden opportunity that I just wish I could have been able to do for her.
What was the conclusion?
The conclusion was that the other side, they granted the motions to dismiss because she had listed the CEO people in the cases and not put any reason why, what harm they had done to her in any way. She had only said some kind of argument about notice of appearance. It hadn't made any arguments about the CEOs. So the judge granted her motion to the other side's motion to dismiss and motions to quash. He also allowed her to amend her complaint. So now she gets to redo a whole amended complaint, and that's a good thing because she probably really needs to. But as far as missing the opportunity when he said she had gotten a loan and there was she wasn't arguing that she had a loan. Oh man, that was huge. She kept arguing there was this broken chain of title, which there was pursuant to the deed of trust in the note, but she didn't know how to argue it. And they came out and just said their documents were right and correct.
Why were you there, Cindy?
I don't know why I was there. I have the goodness of my heart. Other than that, I don't know why I was there.
To witness her madness.
I left. I got so mad I walked out eventually. I know, John, you followed me out. I was pretty upset. But I did want to say one other thing. John brought this up. They are impeaching me personally about my affidavits. But what they're saying is that, oh, that Cindy Cantrell, she's got a case against Brian Moynihan trying to get her house. Really? How do you think I got to be an expert? I know what these guys are doing because I've had to do a ton of research for my own case. And yes, I am trying to stop unlawful conversion. I am trying to stop criminals from stealing my property that have no lawful right to do